right, good day and welcome again. Employment Law Show. John Scholes here. Beside me, Lior Samfiru, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed employment law firm in this wonderful country of ours. I will tell you right away before we get into the show over the next half hour how to reach out. 1-855-821-5900. Email address we use is help@employmentlawyer.ca. Simple, right? And a website I know Lior refers to all the time, either here on the TV show or our radio show as well, pocketemploymentlawyer.ca. And if you go to employmentlawyer.ca, that website, the media tab, you'll find a radio station near you across this country that carries the show. So we'd like to have you join in any time for that hour-long broadcast as well. But this is TV. We got lots of stuff to cover today on the show, Lior, including the guide on handling bullying and harassment in the workplace. We'll get to those talking points, so stick around for it. But first, always, the week that was. You got something cooking on your end, pal. How are you?
John, I'm doing great, and I don't think you'd be surprised to know that a lot of the questions that I'm getting in the office these days still have to do with the impact on the workplace of COVID-19, the pandemic, vaccines, layoffs. So, one day I'm pretty sure I'll get back to doing employment law that doesn't touch on the pandemic, but right now, every single day, I'm answering a lot of questions about, what to do if my employer makes me get the vaccine, or if I lose my job because of my vaccine status. What if they put me on a layoff or they change my job? So by all means, if you ever find yourself in a difficult workplace situation because of the pandemic, like so many people have, we'll give you the contact information so they can reach out to me in the office. We can have a private chat or an email exchange so that we can get your problem solved and you can walk away knowing what you need to know about your workplace rights. And we take this opportunity here once a week to advise and inform you and educate you on your workplace rights. Believe it or not, in Canada, we have some of the best employment laws in the world. And because of that, you have a lot of rights, but your rights can't help you unless you know what they are. And that's the point of this show, to advise and inform you about those rights. Mm-hmm. Now, I told you a lot of pandemic questions I'm getting. I'm actually going to start off just to change things up, tell you about a situation that came across my desk that does not have anything to do with the pandemic, just because I think there's some important lessons to learn. I spoke with a lady that's been off work for about 8 months or so because of a medical condition, non-COVID related. With the doctor support, no issues there. Recently, though, her employer decided to shut down the department that she was working in and let go of probably about 17 or 18 people in that department, including her. Nothing to do with her. They're not picking on her. Now, the employer offered severance to all these employees, but when it came to her, they offered her no severance. So, of course, she called them and she said, well, I'm being let go. You're not paying me any severance. What gives? Well, her employer said, well, we're not giving you any severance because you're not able to work anyway. So even if we weren't letting you go, it's not like you were earning any income. So we're not going to pay you income when you're someone that's not working. That didn't sound right to her, and she called me. She did the right thing. She called me, and we had a chat. So let's be clear here. This employer is dead wrong, completely wrong. The fact that she is off on a disability and not earning income at the time she is let go does not deprive her of severance, not even close to that. In fact, she gets the same amount of severance she would have gotten if she was still actively working. So when you're off on a disability, you're off on a medical leave, if you lose your job, yes, you absolutely have to get paid your full severance. Arguably, even more severance than if you were healthy, because it's probably going to take you longer to find another job if you're sick, if you have a medical condition. So yes, she gets severance. It's a wrongful dismissal. I'm going to help her, but that's an important lesson there, a lesson to employees and employers.
As far as being on a disability, if she's on sort of disability coverage, disability leave, does that change? Because a lot of employees think that if they lose their job or if the company shuts down or lets them go, that will stop their disability payments.
That's a very good question, a good point. So if you're off on a disability leave and you're receiving disability benefits from an insurance company,
right.
If you lose your job, you do not lose your disability benefits. That coverage does not stop. The only time you will stop getting disability benefits is if you're no longer disabled or if you've reached the age of 65. But losing your job, if you're on a disability plan, is not going to change anything. Keeping in mind, of course, that oftentimes insurance companies try to get you off their payroll before they should. If that ever happens to you, we have a whole department at the firm just dealing with that. You have to reach out right away.
You know, it's interesting. You go back to the severance question. You mentioned she was part of a whole department that was either let go or shut down. Sometimes employees or soon-to-be ex-employees are going to compare notes, right? Saying, well, we're similar age. We seem to have the same gig. I've known you for a lot of years. How come your severance is either so much less or so much more than mine? And people think that's wrong.
Well, chances are both those employees that are comparing their severance, both are owed actually more. And the reason for that is 90% of employees, when they're let go, are offered a lot less than what they're legally owed. So chances are, if you're comparing with your colleague, you're both getting less, and you should both get advice. But regardless of that, the factors that go into assessing severance are individual to the person. So your length of employment, your age, the type of job that you do. So that's why it doesn't make any sense to compare your severance to someone else's unless they're the same age, same position, same length of employment as you. So either way, you have to get advice. Chances are, if you're staring at that severance letter, your employer's offered you whatever they've offered you, I can almost guarantee you that you're owed significantly more than that, because in most cases, that's simply the case.
Again, reaching out 1-855-821-5900 anytime to Lior and his team. Help at employmentlawyer.ca. And I mentioned employmentlawyer.ca, the website that is ready to go to catch a radio show near you. We've been doing that for almost a decade. A lot of callers call in every week on the show with so many questions. Lior, we'll get to our first call from the radio show right now.
Concerned about my severance package. I was with a trucking company for 25 years. Your driver, no union, no notice. Just I came in from my day's work and parked the truck and went in the office, and that was it. Asked to leave. Rather than fire me, they suggested a retirement package, which was 8.5 weeks of severance. There's no paperwork. I had no notice. Just wondering if that's appropriate.
Wow, generous.
No severance, no paperwork, no notice, no employment laws, I guess, apply to this employer. Ridiculous. And as outrageous as this sounds, and it is outrageous, I've seen this exact scenario multiple times, John. So let's be very, very clear here. If you lose your job, you're owed severance. Okay, I don't know that I could be any clearer than that. The employer doesn't get to avoid that by calling it retirement, by calling it a layoff. Doesn't matter. If you lose your job, you are owed severance. Now, this guy is owed a lot more than that 8.5 weeks pay that his employer says he's owed. So I can tell you now how much he's owed, but I want to show you how much he's owed and how you can find out yourself how much you're owed. So simple. We're going to go to our severance calculator at pocketemploymentlawyer.ca. We're going to use our severance calculator there. We're going to plug in his information, and we'll see exactly how much he's owed. So let's do that. We know that this guy is a truck driver. We know he's been there for 25 years. Let's assume that he's in his 60s. We know that he was offered very generously 8.5 weeks pay, but you see in the bottom of your screen that he's owed as much as 24 months pay, anywhere from 20 to 24 months pay, depending on the salary. Well, that's going to be somewhere in the six figures for sure. So as quickly as I just did this right now, you can do yourself. If you're lost your job, if you're worried about losing your job, or if you're just curious, just go to pocketemploymentlawyer.ca. You'll see our severance calculator, free and anonymous, so check it out.
I've seen bad severance offers, man, but that's like 10 cents on the dollar. That's like embarrassing.
It's embarrassing, and how many people, though, John, don't know any better? And they would accept that or would walk away not thinking that they're owed more. And that's really why we're here, to avoid that situation. We don't want it to happen to you, that when you find out down the road when it's too late that you were owed more. If you've watched us now, if you know someone that's in that situation, you and them should know better.
We also mentioned off the top, terminationquestions.com. It's exactly that. Questions about your termination, your particular case. It's free and it's anonymous. You just type it in there and it'll be replied to and answered quite quickly by a member of Lior's team. First one for today, pal, coming at you. This one from Lysel. Lysel says, my employer has proposed reducing my work week from 5 to 3 days. Is there any way to accept this temporarily without it resulting in a permanent change? I've been told this is due to the pandemic and my schedule will eventually revert to 5 days again.
So this is not uncommon with an employer changing the terms of employment because of the pandemic. And I want to make it very clear that even if it is because of the pandemic, an employer does not have the right to make unilateral changes to terms of employment. No, they can't reduce your days or your hours or cut your pay or change your shifts. They can't, even if it's for a legitimate reason. If they do, that results in what we call a constructive dismissal. You can treat that as a termination and get your severance. But what happens is, as this person, what happens if you want to continue working, but you don't want it to be down to 3 days permanently? So what do you do in that situation? Well, you have to have an agreement in writing with your employer that this reduction, this change, is only for a specific period of time. Okay, if it's not in writing and you simply continue working, then unfortunately you're stuck in that. But if you and your employer confirm in writing, email is fine that, okay, we're only going to do this for 3 months. Fine. After 3 months, if you're not back to 5 days a week, you can still treat that as a termination, treat it as a constructive dismissal. But you need to specify a time period and in writing. Remember, if it's not in writing, it doesn't exist.
Now, at the end of the 3 months, if we forecast a little bit and think at the end of the 3 months this person is let go, we're not going to bring you back to 5 days. Sorry, out the door you go. Their severance is based on the previous, though, not this lower amount of time, of course, right?
Well, here's the thing, actually. Here's where you can protect yourself. So if you've agreed with your employer that for 3 months I'm going to be at 3 days a week, right, and after 3 months I go back to 5. If at the end of 3 months, instead of bringing you back to 5, they let you go, well, no, that severance now is calculated based on 5 days a week, because after 3 months you're supposed to go back to 5. So you're protecting your severance there as well. So don't just accept changes to terms of employment by continuing to work, because if you are silent, if you just continue working, you've accepted these changes potentially forever, regardless of your actual intentions.
All right, coming up, bullying and harassment, how to handle that in the workplace. That's coming up in just a moment. Stick around for that. In the meantime, reaching out, 1-855-821-5900, help@employmentlawyer.ca. It's the Employment Law Show. More's coming up. Don't go anywhere. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the Employment Lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the Employment Lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks so much for hanging on there for a moment. Back to the Employment Law Show. Lior Samfiru beside me, the most positively reviewed employment law firm in the land, Samfiru, Tumarkin, LLP. Let's get to this, pal. Guide on handling bullying and harassment in the workplace. Super, always an important topic. So let's get right into it. First point, I guess, is what is harassment in the workplace, and can it only happen within the confines of the workplace?
So, John, when I started practicing law some 20 years ago, we didn't talk much about workplace bullying, workplace harassment. That wasn't really a thing, and not because people were not treated in a bad way. It was not a thing because I think there was a stigma attached to talking about it. People didn't feel comfortable acknowledging that, yes, I'm being bullied in the workplace. Luckily and fortunately, things have changed significantly over the past number of years, and now people understand that, wait, I have rights. I don't have to accept being mistreated. I don't have to accept being in a poisoned work environment in the workplace. So that's a right that I have. I should be working in a healthy environment, and I can do something about it if I'm being mistreated. So workplace harassment, workplace bullying is a very common issue that I deal with, that I see, and I want to make sure that people understand that the law is on your side. Now, when it comes to workplace harassment, what are we talking about? Well, it's a very broad term that refers to any type of workplace behavior that would be considered unwelcome. Okay, so that can be anywhere from using inappropriate language to putting people down to making sure that people feel bad about themselves. You name it, it all falls under the rubric and the category of workplace harassment. Now, we'll talk in a second about the fact that employers have an obligation to do something about it, But workplace harassment is not necessarily just confined to what happens at work between 9 to 5. So if you're being harassed or mistreated by a colleague off work hours, that is also something that's inappropriate and becomes the employer's problem because it could spill into the workplace. If you have a conflict with a coworker off hours and it's going to impact your ability to work, well, now it becomes a workplace issue. An employer can't ignore that. So John, workplace harassment is something that we all must take very, very seriously.
Second important tip on this topic is this, Lior. You want to document all incidents of bullying in some manner, preferably, as everything else, in writing.
So if you're a victim of workplace harassment and bullying, the first thing you need to remember is that the chances are that the person that's doing the harassment is not going to admit it. They're not going to put up their hand and hang their head in shame and say, yes, we did it. So it's up to you, the employee, the individual, to document this in some way, in writing, either it's by email or having a journal or a notebook or even a recording or a witness. You need to be able to record it because when we're going to deal with it, we're going to be able to show that what you're saying happened actually did happen. So remember, having that record, keeping notes, making sure that there's something contemporaneous is extremely important to eventually eradicating that workplace harassment. Oftentimes, your word against someone else's is going to be very difficult to deal with.
And I think the third point as we get through these, we're talking about dealing with bullying and harassment in the workplace, and that is don't let it just fester. I mean, reach out to talk to somebody or the HR department or whoever's in charge of dealing with these things in your workplace, right?
So you've done what I said, you've documented, there's a way to show the harassment, the bullying. Now you have to do something with it and about it. So what do? You talk to someone. You have to let your employer know about that, whether that's HR or the owner, or maybe there's another designated person in your workplace that has to deal with these issues. But you have to tell your employer and at least give your employer an opportunity to resolve that issue. Now, sometimes that's not possible, in which case we have to skip a few steps and contact me if you can't deal with it internally. But if at all possible, you have to try to talk to someone, go to them, send them your proof, your evidence, tell them what's happening, put the ball in their court to do something as they're legally obligated to do.
Now, when you say it's not possible, could that be the scenario where it's maybe the boss or the person you're supposed to be reporting to, they're the one doing the bullying?
Right. So you may be working at a small little company. It's you and the owner and someone else,
right,
and it's the owner that's mistreating you and bullying you. Who are you going to talk to? There's really no one in that scenario. At that point, we skip a couple of steps and we deal with it through me, deal with it externally. But that's the exception, not the rule. As a first step, if at all possible, I want you to deal with it internally.
It's interesting too, because the fourth point kind of dovetails into that. People think, okay, well, I'm going to report it. Maybe it'll lay low and nothing will ever happen. It is the obligation. They're obligated to invest any allegations and not punish you if you do so, right? You can't lose your job for bringing it about to your boss or HR, right?
And it's not just a moral or an ethical obligation, it's a legal obligation.
Legal, yeah.
The law makes it very clear that an employer that becomes aware of workplace harassment, workplace bullying, has an obligation, number one, to take it seriously, of course. Number two, to investigate, to take all measures to investigate that issue, whether they do the investigation, sometimes maybe even bring in an outside investigator who specializes in these things. And finally, where harassment is found to have existed, your employer has to do whatever they can to make it stop, to make it go away, whether it's by providing training, disciplining someone, letting someone go, relocating employees, you name it, they have to make it stop. They can't just accept it. Gone are the days of, boys will be boys. That's no longer acceptable. An employer has to do that. And you cannot, under any circumstances, be punished or disciplined for bringing up a harassment complaint. Even if it turns out that you can't prove the harassment, you still cannot be disciplined. You're protected. The law takes these things very, very seriously.
I think the final point worth making on this topic for today, Lior, is that even if, you've gone through the appropriate channels, the lawyer's done a little bit of investigation, but they haven't been really robust about it, you're not getting any satisfaction. They should not hold back in reaching out to you to take it to the next level, no?
So I've just told you what the employer's obligations are, legal obligations. If they meet those obligations, problem solved. If they don't meet those obligations, they don't take it seriously, they don't investigate, or maybe they just don't care enough to do something to fix it, or they don't do enough to fix it. In that situation, yes, we need to speak. you can treat this whole situation potentially as a constructive dismissal by the employer putting you in that situation, by them not resolving the issue and you having to work in a poisoned work environment. That may be a constructive dismissal. Depending on the situation, it could also be a human rights violation, potentially. So yeah, if you've exhausted the internal options, let's talk, let's deal with it externally. There's plenty of things you can do that way.
Look, if you have any other questions or remarks about the topic we just covered on this show today, you can do so. Reach out, 1-855-821-5900, help@employmentlawyer.ca. As we mentioned, Lior, several times during the show, through Ontario and BC, Alberta, we have radio shows across the country pretty much. Tune into those. You'll want to find one, go to the website. And call number 2 from one of our radio shows is coming right now, pal.
About my wife, she was an hourly worker and then was accruing a lot of overtime. So they made her salaried, but now she's accruing even more hours, over 44 hours a week. Just wondering if she's entitled to overtime.
What kind of a job does your wife do?
She does kind of a marketing, analytics, administrative type job.
And is she a manager? Are there people that report to her?
Not one person.
Good call. Great call.
Excellent question and a common issue. So obviously every province has their own threshold when it comes to overtime, how many hours you have to work before you get overtime. This person in Ontario, the Ontario threshold is 44 hours a week. So if you work more than 44 hours a week, you are owed overtime, time and a half, anything over 44. Now, in this situation, even if she's on salary, she gets overtime. It's simply calculated. We look at what her weekly salary is, divide by 44, and time and a half is her overtime rate. Even if her employer didn't tell her to work overtime, she's owed it if she did it legitimately. And as long as she's not a manager, in most cases, managers are exempt from overtime. And in this case, he said that she's not a manager. There's no one reporting to her. Then yes, she is owed overtime. They have to pay it and they can't avoid it. I can help with that with respect to overtime. The Ministry of Labor or the Employment Standards branch in your province can help with that. But yes, overtime must be paid. It's not optional here.
You mentioned that even if she worked it, she has to be paid for. What if she basically had instructions from her employer saying, don't work overtime, please don't do it, but she had to do it to get the job done anyway?
So if overtime is worked and if it's legitimate, it has to be paid for by the employer, even if the employer said don't do it. Now, if the employer said don't do it and she does it anyway, that could become a disciplinary issue. But that still does not allow the employer the ability to avoid paying for what's been worked. So employers have to understand that. Employees have to know that if you've worked it, you have to get paid for it.
Fantastic phone call. I want to get to one more, Lior, but we got to take a break first, so we'll do that now. So stick around for that. 1-855-821-5900. Anytime to reach out to Lior's team, and help@employmentlawyer.ca. Coming right back.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, so good to have you along this week. By the way, you can reach out anytime to Lior and a member's team for a more private, lengthy chat. 1-855-821-5900, help@employmentlawyer.ca through email. And finally, the website, pocketemploymentlawyer.ca, anytime as well. Radio shows across the country. Been doing them for almost a decade. Lots of phone calls. Lior, phone call number 3 from the show. We'll talk about it afterwards. It's coming up right now.
February of last year, lost my job, downsized in the oil and gas industry. But previous that, a year previous that, we did a contract change, and the contract change was not in my favor whatsoever. Went through 3 contract changes in 3 years. Didn't want to sign it, was forced to sign it, or I didn't have a job. And now I have a non-compete for 3 years. Is that enforceable.
3 years.
That's a very long non-compete, and
That's
let's
retirement.
be very clear here and honest that if you're already working and your employer comes to you and says, I want you to sign a new employment contract, that's never a good idea. It's never good news. You're never going to sign that piece of paper and be better off than you were prior to signing it. So always something to keep in mind that it's a good idea to say no, or at a minimum, let me see what they want you to sign before you go ahead and sign it. In this situation, one of the things that the person did by signing it is agree to a 3-year non-compete. Now, the good news is that unless you're an executive working in an industry that's extremely unique, there's no court that's going to enforce a 3-year non-compete. It's simply not going to be enforceable. So in a way, I can tell you that you may not care about it. That said, that doesn't mean that your employer or former employer won't try to enforce it. So you may have a legal battle on your hands. So you have to take these non-competes seriously. Some provinces, like Ontario, have started completely outlawing non-compete agreements, so you may have the benefit of that depending on where you live. But generally speaking, my rule is this. You don't sign something unless you're willing to live with it. So before you sign, let's talk.
You want to do that? Reach out, 1-855-821-5900. I want to get one more shot from terminationquestions.com, Lior, before we wrap for the day. This one is from Craig. Says, I was recently terminated from my job as a seasonal machine operator after working over 10 summers with the same employer. Am I entitled to anything as a seasonal worker?
So seasonal work is a very common question about them. So seasonal worker works a specific period of time during the year, then they're off, and then they come back when the season starts again. And that's absolutely fine. But what happens if your employer says, this time you're not coming back, this time we're not going to bring you back? Well, at that point, it becomes a termination and you're owed severance. So yes, bottom line is if you're a seasonal employee and your employer now decided not to bring you back when they're expected to and supposed to, that's a termination. You get severance the same as every other employee. So we know this person's been there for about 10 years, worked there for 10 summers. He's owed significant severance. But let's go to pocketemploymentlawyer.ca again. Let's plug that into our severance calculator, and let's see exactly how much this person is owed. So machine operator has been there for 10 years, 59 years of age, no severance offered. You see at the bottom of the screen, he's owed as much as 10 months pay. 10 months pay, that's a significant amount. So you can check it out for yourself at pocketemploymentlawyer.ca. And the lesson, as I said, of course, seasonal employees, yes, you are absolutely owed severance if you lose your job.
Do you think it's on the employer side, they figure it's just that big lapse? I mean, for instance, you work at a golf course, you're not working all winter. They just figure it's that lapse of employment. Why would I pay you severance? You're only here for the summer.
Absolutely, they may think that. And if they only hired you for one summer, then that's fine.
Right.
Then they don't need to pay you severance. But if you've been there like this person for 10 years, every year you go back in the spring, you work to the fall, and then you come back, etc. Now it becomes an employment with regular schedule, which means severance has to be paid if you lose that job.
It's kind of like hiring, filling contracts every year for 10 years, and in the 11th year you're not offered a contract. Similar type thing, right?
Happens all the time with fixed-term contract. You sign a contract every year, then another, and then another, and at one point the company says, this time we're not going to give you a contract, so goodbye, we don't have to pay you anything, the contract just expired. No. Usually if you sign more than 3 contracts, you become a regular indefinite employee. Then that means you're owed your severance like any employee that has no contract.
That is it for another show. We'll join you next time. Thanks for joining us. 1-855-821-5900. Always the number to reach out. help@employmentlawyer.ca. Email address, and then finally, pocketemploymentlawyer.ca anytime as well. Free and anonymous. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.